But today, we're going to talk about what are reasonable measures when it comes to protecting your trade secrets. And I thought there are some really timely news events going on that have come into the fore recently, or brought trade secrets and the protection thereof to the spotlight in a way that really hasn't happened until now. And as we've been talking about throughout this whole series, this is sort of an evolutionary thing where organizations are learning more about the law around trade secrets, how to protect them, what are reasonable measures. And up until now, there's been very little regulatory scrutiny or regulatory requirement around the identification and protection of trade secrets, which I've been predicting for 2.5 or 3 years now it has to change, because in my opinion, these assets are more valuable to most companies and more critical to our infrastructure and our economy than PII or PHI. Yet those are the assets that are protected by most of the governing laws on the books. And that's just never made any sense to me. I did cyber insurance for 20 years, and it never made sense to me then either. So I wanted to start with some of the headline news and recent things that have happened just in the past few days. And certainly this can be interactive, or we can wait until the end to have kind of a dialogue or Q&A. But essentially, I'm going to start with SolarWinds and Okta. Both of those were in the news this morning. And the biggest issue regarding each of those really is that, well, a couple things. SolarWinds just was sued by the Securities and Exchange Commission for the first time ever for a cyber breach where an individual was named and the settlement didn't occur at the same time. That is a really big deal, and I think it sends shockwaves across the country and will continue to reverberate with CIOs, CISOs, and other people who are responsible within an organization for information security, because it shows that they're personally liable, potentially, if they not only sort of cover up the events behind a particular circumstance that's occurred to their company, but have also sort of underplayed the vulnerability of the firm and or overstated how secure their system was. The SolarWinds issue resulted, importantly, in a 35% stock drop by the end of the month following their 8K announcement of their breach back several months ago. And most of the news reports would say, because of the impacted customers of theirs were all critical infrastructure companies, mostly a lot of federal agencies, including the Department of Homeland Security and some others, that we may never know the full extent of the result of what happened from the SolarWinds breach, because they're not public companies. They have no obligation to disclose anything. But it does sort of raise a lot of issues around obligations to disclose, having a process in place to respond that's not privacy related, but really is more about protecting critical infrastructure assets. Those are not necessarily trade secrets, but they absolutely can be. Similarly, Okta, just as an FYI, they had a second breach that was notified. Similarly, they impacted several hundred companies as customers, and it was the second almost identical breach that's occurred to them from the same circumstances, and the same vulnerabilities were exploited. And they were told multiple times by several customers that they thought there was an issue on the system with the security and the vulnerabilities, and they didn't do anything about it in one case, for 17 days. And in the cyber world, that's an eternity to sit on something when clients are telling you that there's a disclosure or a security breach issue. As a result, their market cap is down $2 billion just between Friday and Monday. So it just goes to sort of underscore that these breaches are a big deal. And the way that they tie back to trade secrets is what I'm going to get to next, which is really the first bullet point. And that is that recently, the cybersecurity disclosure requirement, a rule passed by the Securities and Exchange Commission, I think really is going to be a game changer in the world of trade secrets, even though it's really getting most of its noise in the cybersecurity echo chamber. Excuse me. And the reason I say that is that if companies are now obligated to disclose when there's been an event that has the potential even to have a material impact on the future earnings of a company, they have to disclose within 4 days of discovering that that cybersecurity breach will be material. So 4 days from the materiality discovery, they have to disclose that. And when they do, they have to file an 8K. They also have to, in their 10Ks and 10Qs, on a go forward basis, talk about all of the security policies and procedures that they have in place around the protection of those assets, the capability to, sort of contain the event. And they have to notify going forward of any circumstance that has happened prior to this rule going in place, effectively making it a retroactive requirement for them to notify on things that may have happened in the past that could have a material impact on the company's earnings. Why is that a big deal? Because so many trade secret in specifically or cybersecurity breaches that don't impact PII or PHI, where there up until now has been no regulatory requirement. So many of those breaches go unreported because companies don't want people to know that they've had a misappropriation event or a big event that impacted something other than their PII or PHI. And so it sort of begs the question, how are companies going to know if they had a breach that could impact their earnings at a material level going forward? This wick is kind of itchy. How are they going to know if they've had a material event if they don't know what their trade secrets are in the first place? And so it sort of, to me, takes the whole idea off the table, which was the subject of one of our prior discussions around whether or not organizations should, in fact, be identifying trade secrets and trying to put a value on them. Again, how are you going to know if something's material if you don't know what the trade secret was and you have no idea how much it was worth before it went missing? So I think this really is a game changer on a lot of levels. And the 8K requirement then will trigger very immediately responses in stock price and potentially lead to D&O claims and other liability issues associated therewith. D&O policies, I'm not going to sort of talk about D&O a lot today, but certainly there are regulatory coverage provisions in there that may or may not most likely cover the entity. And so, talk to your D&O broker about that. But I think this is going to have ramifications in the cyber market, the D&O market, and certainly for trade secrets all the way around. The second thing is that we recently reported on something that was posted by Visual Capitalist, which is an organization that I follow very closely. They have really great information, taking global trends and boiling them down to an easy to digest format. But essentially, they reported that the top 10 companies in the NASDAQ spent in 2022 $222 billion in R&D with a B, just the top 10 companies. Of those 10 companies, on average, they had increased, that's a spending increase in R&D of over 30% in the last 24 months. Some of them, that increase had just been in the previous 12 months. So the R&D spend for most companies today is far greater than it's ever been before, especially for tech companies and all the NASDAQ companies. Most of them are very tech heavy. But still, it's sending a sort of a reminder to everyone that R&D spending is way, way up, and that's where most trade secrets live. Everything that's in a company's R&D pipeline, almost by definition, if it's gotten to the point where it has legs and they're spending a lot of time and energy on it, is a trade secret, because at that point, you're putting extra measures around it to keep it secret. You're wanting to see if it is going to be that differentiator that's going to either drive revenue for the company or help you save money in an efficiency way. Certainly,
Where'd it
obviously.
go?
Pardon? Gary? Were you
Yeah, I'm
talking to
sorry.
someone
That
else?
was not directed to you. I thought my microphone was off.
Oh,
I'm sorry.
no problem. I was like, is everybody okay? Anyway, so R&D is a place where a lot of these assets live. Obviously, if something is already out and being sold or being used by yourself or by your customers, but you're simply improving upon and continuously improving upon that asset, then it may not be an R&D spend anymore, and it may be out in the public domain. But these are massive, massive numbers, and I think a good way to know whether or not your own organization or your clients, as the case may be, have a lot of trade secrets is simply to look at how much money they're spending in R&D. Most of these companies, 7 of the 10, were spending 10% of their annual revenue or more in R&D. So that tells you how valuable these assets can be to the organization. And then finally, the 5 Eyes, which are the United States and 4 of our allied nations, have cybersecurity experts that, sort of coordinate and get together to try to fight adversaries around the theft of intellectual property and the theft of critical infrastructure assets and other things. And they, for the first time ever, felt compelled enough to address Congress to tell them how bad the problem has gotten specifically with China. They're not the only country that's trying to infiltrate and steal, our intellectual property assets. But it was a very telling news conference that they had. There was a 60 Minutes special about it. I think it was 60 Minutes, just a Sunday or so ago. That was really interesting. For those of you who haven't watched it, you should. So there's a lot going on in favor of identifying, and at least relative to the other trade secrets or assets in your portfolio, putting a value on the assets so that you can develop a process and be able to demonstrate that you are putting reasonable measures behind those assets to protect them, or else they're not trade secrets, period. That's what's leading us to the next slide. And to the topic today, which is what are reasonable measures. So in trade secret law, this is one of the most confusing things. And I think a lot of organizations, you may have seen the slides that we've put up in our previous Trade Secret Tuesdays that talk about the average cost to bring a trade secret claim against a third party. Average is 4.1 or $4.2 million in litigation expense, and it takes almost 3 years for a case to go all the way through to trial. And that's for a relatively low value asset, somewhere between 10 and 25 million. I mean, that's still very significant. But if you've got assets that are worth 25 million or more, the length of time and the expenditure to litigate increases exponentially. So imagine how disheartening that would be for an organization who believes, and in fact can prove, that their trade secrets were actually stolen, or that assets that should have been qualified as trade secrets because they provided value to the organization and a competitive advantage, and they were grown in-house, were disqualified from protection simply because the reasonable measures were not there. That happens 11% of the time, according to statistics brought about in Lex Machina's report. This was an older stat in 2020. I wouldn't be surprised if the number's higher since then, but it's a very relevant problem, which, since reasonable measures are one of the things that determine whether or not something is in fact a trade secret, it essentially disqualifies the asset as even being a trade secret if you can't demonstrate that you put reasonable measures. So reasonable measures, and the reason that there's so much controversy about this is that they are very fact, case, and company specific. So the reasonable measures for my company, which is a startup, to protect our trade secrets might and should be very different than a Fortune 1000 company that has many more resources, but also many more employees working for them. So they may need to document a lot more things in writing, get things signed off, work a lot harder potentially on their access controls, but at the same time, for a smaller company, everybody's got access to almost everything. And so your policies and procedures around protection of the innovation assets need to be different. And you have to be able to explain what you were doing to protect those assets and why you were doing it. And unfortunately, it's no longer enough, according to a lot of the case law, and we'll talk about some of these cases in a minute, to say that you were using the same security measures that you were using for other information, even other types of confidential information, potentially. So I would argue, and I've been to a couple of recent trade secret conferences where this is a big part of the discussion, that if you can't tell a jury or a judge that you are using at least the same remedies or the same protections around protecting your trade secret assets that you are your personally identifiable or PHI, you're going to have a hard time convincing them that you're doing what you need to be doing. So the first thing is around technical controls. We don't have tons of time to spend on each issue, but obviously there need to be access controls, physically limiting who can reach into those systems and access them. There need to be physical access controls. If the trade secret is not on a network somewhere, it's on the manufacturing floor, then you need to have certain policies and procedures around who can access that. I think some of those are fairly obvious, that you just need to be doing the right thing and using industry standards or better around technical and DLP access and encryption controls. But we're going to spend a little bit more time on non-disclosure agreements, non-competes, and hiring and firing procedures, because that's where I think most of the courts today are not spending a lot of time. In fact, they're not really hiring information security experts per se to say, were the technical controls robust enough? I think that will change. I really honestly believe that. And you're going to start seeing information security experts be called as expert witnesses. But for the moment, most of the case law around trade secrets is on these other things, which are non-disclosure agreements. First of all, what does the definition of confidential information say in that non-disclosure agreement? Is it broad enough or too broad? In other words, have you said that every single piece of information within your organization is quote unquote confidential information, or that it could be confidential information? Are you marking everything as confidential and proprietary even when it's not? There's a lot of controversy and actually some case law that's turned on organizations who said they had a policy to mark everything as confidential and proprietary, but then failed to mark certain assets as such. And then the court was just essentially dismissed the case, saying, well, this can't be a trade secret if you didn't mark it and you said that was your policy or procedure. Conversely, if you overly mark everything, then nothing can be a trade secret. So there's a fine line there, and a lot of discussion around markings of confidential information and what to put in your non-disclosure agreement. Let me just back up and say that it is absolutely essential that when you're sharing information that you believe to be a trade secret with any third party outside the organization, you absolutely need a non-disclosure agreement in place. According to Greenberg Traurig, that is the absolute #1 thing that comes up in defense of trade secrets. It's more important than anything else to have a non-disclosure agreement limiting the use and or disclosure of that information to anybody else. When you give it to a third party, there's lots of case law on that. It's very clear that you need an NDA. That is a problem, as an aside, by the way, for companies that are raising capital, because venture capital and private equity funds almost never are willing to sign an NDA. And they'll say, don't include your trade secrets in your pitch deck or the information that we're asking for during our due diligence. Well, that's pretty hard to do, considering they want to look under the hood and see exactly what your strategy is, why your tech or other innovation is different, what your distribution strategy is, what you predict your financials to look like. That's going to have to change if companies want to be able to protect their trade secrets. And in fact, ironically, if venture capital and private equity funds want their portfolio companies to have that trade secret protection, they're going to have to start signing NDAs. So that's a whole different discussion, but an interesting point nonetheless. The second thing is there a time frame in there? If the non-disclosure agreement is limited to say 2 years or 3 years, you need to try to carve out as best you can that anything that is a trade secret, as opposed to just other confidential information, needs to be protected forever and ever. And that is a really hard provision to get people to agree to, but we've done it successfully many times, even with very big organizations, once we explain that trade secrets are still trade secrets as long as they're secret. And in order to protect their secrecy, we have to have unlimited time frame on, on that disclosure requirement. But a lot of organizations overlook that accidentally, and it becomes a problem for them later. Let's move on to non-competes. Obviously, non-compete agreements, we're talking about mostly former employees where you're enforcing these. They're becoming less and less enforceable state by state, and there's a federal proposal to ban non-competes altogether. Nobody knows whether or not that's going to happen. But if you can have a non-compete agreement in place, the idea is to make sure that the non-disclosure provision in that non-compete is broad enough that the employee knows that he or she has had access to information that would be or could be deemed as a trade secret or highly sensitive confidential information by your organization, and that they are not to share that with anyone else. However, you don't want it to be perceived as overly broad by saying that everything that they ever worked on or had access to when they were at your company is protected information, because employees are allowed to learn things when they work for you and take that knowledge elsewhere. And again, it's a really fine line to walk. The Sedona Conference is actually putting out some guidance on that. And there was a big debate at the Sedona Conference about whether or not to just write into non-disclosure agreements that knowledge gained while they're working for you, if it's not for a project specifically created by your organization and for your organization, but just their knowledge as an engineer or a salesperson or whatever, that is carved out so that you can't be accused of having overly broad wording in your non-competes. It's a really sticky issue, but I would suggest that people, again, talk to their attorneys about exactly what to put in these non-compete agreements as long as they're still enforceable. Hiring and firing or termination policies are huge, and training. So when we look at an organization to determine whether or not they qualify for our trade secret insurance, two of the things we look at are hiring and termination, and one is training around what is a trade secret, how do you protect it, how do you mark it. You need to limit access to only certain employees on a need-to-know basis. Not everybody should have access to information that could be deemed as a trade secret, or else, again, you're going to have a really difficult argument from the get-go, spend a bunch of money litigating a claim, only for the judge or jury to say, well, if every person in the organization had access to it, i.e. customer lists or pricing lists, it's not a trade secret. That happens a lot in those types of cases. Hopefully the crown jewel assets are not available to everybody, but if they are, that's definitely something that you need to consider doing something about. The hiring part is really important because companies can absolutely be held responsible and actually be brought up criminally for allowing or encouraging people to bring trade secrets from a previous company with them. In fact, they have a duty to make sure that those employees know that that is not acceptable, that they are not expected, or they're not supposed to bring trade secret information from a prior company with them. You can go so far as to look at their look at their own devices and things, and that's a little bit harder to do, recognizing that. But if you have a BYOD policy and they were allowed to use their own laptop at a previous company, you want to make sure, get them to sign something, for example, saying that they don't have any information on their personal device. And certainly you don't ever want to see any of that information on your own network. And then certainly termination, it's critically important when somebody leaves the organization that you take all of the written and other materials back that you said you were going to take in your policies around this, and that you terminate their access electronically to everything. Again, it's much harder with BYOD, but that's something to look at and contemplate in a serious way. And then finally, once again, when they're leaving, ideally you get them to sign something again, confirming or affirming that they're not taking corporate confidential information with them and that they understand that there are severe consequences of doing so, et cetera, et cetera. Next. I know we're running out of time, so I'm just going to be really quick. I'm not going to go through each one of these, but I want you guys to read them. We've talked about the various reasons why some of these cases are going the way that they're going, but you can get a huge laundry list of claims where an organization potentially even was able to prove that the innovation was their independently developed asset and that it was valuable to the organization, but the claim fell apart either very early and was dismissed before it ever got down the path, or it went all the way through a jury trial, only for the plaintiff slash victim in this case to lose on the basis that it wasn't protected using reasonable measures. And there are a lot of, again, examples here. There's some really good articles put out by various law firms on reasonable measures and case studies around them. So I'll let you look at those at your leisure. Lindsay? I think you guys all know this by now, but this is really the due diligence process that we've developed called Crown Jewel Protector that we actually give our clients. We help them all the way through the process of identifying the assets and documenting their existence very securely on blockchain and using NFTs. We then value the trade secrets, at least for insurance purposes. It may not be the full fair market, future potential value that you could possibly argue in a damages, if you brought damages experts to the fore, but it is a value as of a point in time, and at least it tells you what your trade secrets are worth relative to each other. Again, getting back to that obligation to be able to disclose it in 8K if you're public, but also just for your own purposes, knowing what's more valuable than something else so that you can apply different and stronger security methodologies around those. Then we look at the protocols we just talked about, the hiring, firing, training, and all the technical procedures. And when all that's done, we give you the insurance. And so we kind of seeing this coming down the road and having all the experience in cyber and everything else, basically created our own best practices for what we want to see as due diligence around reasonable measures and the identification and valuation of trade secrets, and built it into this process because most companies haven't done that. So certainly if you have more questions about that, we're happy to answer any of those for you. And there's a crazy amount of information on our website and on LinkedIn and on YouTube, and we've got podcasts and everything else. Next, Lindsay. So we're out of time. I'm certainly have got 5 more minutes if anybody wants to ask any additional questions. Otherwise, we're going to talk a lot more about the insurance and how it works at our next Trade Secret Tuesday, when I probably won't have this wig on.